He's in the hallway.
So what are your experiences with exclusions?
I've had a few where people say, well, I want somebody, so somebody saw this, I showed the property or somebody said they wanted to buy it.
Right.
And I usually explain that, we need to make it a limited time period. We need a full name contract, and we need to limit the time period. And they'll always say, well, why? And I said, well, because we need to know if they're serious. I need to know if they're serious before I spend a lot of time and money. Right,
on that listing. So let me take that sales pitch a little bit farther. So your point is a good one, which is if you're going to do an exclusion, make it limited, because you don't want to be open-ended with the ability to work for months and months and months and spend money and not get a paycheck. But I think a compelling part of the argument for why no full exclusions. I can't remember the last time I did a full exclusion. I may have never done one, but if I have, it hasn't been in years. So even if a seller thinks they have a buyer that may be on the hook and they ask for an exclusion, my response is twofold in response to why I won't do a full exclusion. One of them is that in the rare cases where because the sellers, of course, before it's on the market, are notoriously bad. They just aren't in a good position to judge how serious a buyer is. And so they think they got a really hot prospect. Frankly, that's the biggest reason I think agents are willing to deal with exclusions, because they figure my seller thinks there's a 1 in 2 chance that buyer's going to buy it. I know there's a 1 in 100 chance that the buyer's going to buy it. But one issue is that it's very difficult for the seller to judge legitimately how strong the level of interest is. But even if that buyer gets pried off the fence and makes an offer after they've been excluded from the listing, what's usually the single biggest factor that pulls them off the fence?
The fact that
exactly.
Yeah,
So if
that they listed it, the seller's serious.
Right. So if it is the fact that it got listed and exposed to the entire open market that pulls the buyer off the fence, then does that not in and of itself mean that there was value in your listing? Absolutely. And the reason in those cases that I would only do, and let me explain another part of that process. So in those cases, the other thing I tell sellers is the partial exclusion will not apply if they have any relationship with a buyer's agent. And so it won't just be if they bring an offer without a buyer's agent, because what I want to be very careful of is I don't want to make the seller and the buyer think, aha, I've been working with this agent, but as we all know, we've seen buyers who have thrown agents under the bus like that if they think there's 2 nickels to be saved. So one of the things I explain to sellers in an effort to try to keep that from happening is, it is in your interest, Mr. and Mrs. Seller, to have a buyer represented by an agent. They're going to tend to be better buyers. They'll also, when they have an expert in their corner, they're going to tend to be more decisive. They're going to tend to be less paranoid and less adversarial, because when they know they don't have an expert and they know that they don't know exactly what's going on, they tend to flail about and be unnecessarily adversarial and just paranoid acting. And so, yes, if there's a buyer's agent involved, I then have an obligation to pay a cooperating compensation on that, but you will probably net more money when it's all said and done, because the uncertainty of a buyer who doesn't have expert guidance getting their way all the way through the transaction, through the home inspection process, it just introduces so much more uncertainty. And you get a good, diligent buyer's agent who legitimately is doing their best job to represent the interest of the buyer, who often will give the buyer the confidence they need to feel like, okay, good, I'm not overpaying if I offer X. And oftentimes that means the seller really can end up netting more money. So that's part of the exclusion conversation is we want, and it's a we, it's not a I'm not going to let you, it's a we, you and I, Mr. and Mrs. Seller, do not want to create any incentive to pry a buyer off of a buyer's agent. And that means that it's not just going to be if the buyer makes an offer that one. I want to know, have they had any working relationship with their agent? So I make sure the seller knows that it's not just an offer that comes in that doesn't have a buyer agent name on it that triggers the exclusion. I need to satisfy myself that there has been no working relationship with an agent, because I want to make sure that I encourage that agent's involvement on the other side of it. That's fair from the standpoint of we want, from a golden rule standpoint, we want to make sure we're paid when we're in that position on the buyer's side, but it legitimately is in the best interest of the seller, I believe. And so that's part of the pitch. The other part of it is I don't do full exclusions because I and most of us deliberately front load our workflow. We want to make sure the minute that the listing hits the MLS that we've got a whole lot of dollars going out the door. For those of you who hire third-party virtual tours, you're writing the checks or charging your credit cards within hours or days of that hitting the market. You're committing to real estate book ad runs. You're doing a lot of front-loaded expenses associated with that listing. So you may have a seller who thinks, oh, well, if it sells to this exclusion in the first 2 or 3 weeks, you've only done 1/10 of the work or 1/10 of the expenditure you would have done if it were on the market for 6 months. Not really. I've done maybe 75% of the work in the first 2 weeks that I would have done in 6 months on the market. And so I make sure that they understand that if they don't think that you're making out like a bandit if the place were to sell right away, they're a lot less likely to object. So if you have the conversation about the fact that your workflow legitimately is front-loaded, that you really will have done 80% of the work in the first 2 weeks, they're a lot less likely to hammer you insisting that they get the exclusion because they think, well, what's it to you anyway? It'll be a windfall if it sells in those first 2 weeks. You won't have spent any money or worked very hard. So that's another point that can help lay the groundwork for getting a seller not to insist on a full exclusion. And then that last part, which we alluded to earlier, is in those rare cases where an excluded buyer actually does proceed with the purchase, it is almost always linked, at least in part, to the fact that the property went on the full open market, and that is what pried the buyer off the fence. And so it's important for us to make the case to the seller in that conversation that therefore that adds value. That's what you're paying a real estate professional for. You are paying me so that your property gets exposed to the entire open market. And the reason that the buyers that will dawdle is because they feel like they've got the inside line. No one else knows about it. It's a well-kept secret. It's all theirs, and so they're gonna sit and bide their time. And what pries them off the fence is when they know that suddenly the whole rest of the world is going to see it. And so, Mr. and Mrs. Seller, even though it may not feel like it if this buyer makes an offer because you feel like you had them in the bag before you and I listed your property together, even though it feels that way, usually if a buyer like that goes ahead and pulls the trigger, it is because I did such a good job at the marketing, it scared the crap out of them that somebody else is going to like it as much as they do. So once you have all of those discussions with the seller, I have found that it is very, very rare that you can't get a seller to start to see from your perspective, oh yeah, well that's not unreasonable. And the other thing I'll tell them is, wait another week. If you think that they're likely to go, wait another week. If you're lucky enough to get that property sold because you already have a buyer lined up and don't need me to put the property on the open market and match you with a buyer, more power to you. We've got other sellers who aren't in that position, so let me suggest, go ahead and give that buyer, say, a week or 3 days. Tell the buyer, I have met with a realtor, it will be going on the market at X time. Because what I don't want to have happen, Mr. and Mrs. Seller, is I can't take a full exclusion. I can't start doing work, writing checks, and get paid less than nothing if you do a full exclusion. And they understand that. When you explain it well enough, they will get that. And so they'll realize, oh, well, that's reasonable. So then, but I'm not greedy. I'm happy. I will genuinely be happy for you if you are lucky enough to sell it without having to pay a professional to match you up with a buyer. So let me suggest that you contact that buyer, put me on hold for 3 or 4 or 7 days. But know that once I show up with the camera, we've got to have a listing that obligates you to pay me, even if that same buyer goes ahead and buys it. Any questions? Any thoughts? So yeah, so when I genuinely feel sad when I see the exclusions in the listings, because I'm thinking, you know, somebody could have just had and it's not a sales pitch to the seller. It's really just, let's have a conversation so the seller sees where you're coming from and recognizes the value in what you're doing, and most importantly recognizes there is value in what you're doing, even if it's because it brings the buyer that they thought they already had in the bag. That brings another related issue up, which is dual and variable commissions. And that's a frequently misunderstood and frequently misused tool in listing agreements. So a partial exclusion would potentially amount to a form of dual or variable commission. And if that is codified in your listing agreement, if there's anything in writing that specifies that under this set of circumstances, if I'm the only agent involved, commission will be X, and if another agent brings a buyer, commission will be this other amount. Anything along those lines that is codified in writing in your listing agreement is a dual or variable commission agreement and triggers a requirement that you disclose that in the MLS. That's another one of those things that I genuinely get sad when I see that in the MLS, because it means that somebody probably could have just explained the variables better to their seller, or it was an agent who was really not valuing themselves very well. So understand that the disclosure requirement is triggered by codifying that in writing. That was one of the things that I said. There is no prohibition against not having a dual or variable commission arrangement written into your listing, but agreeing to do a concession on the fly. And so the way that conversation would work with a seller is, can I get a discount if you find the buyer? No, you cannot, but let me explain. So if I bring the buyer, I will have probably done all the work. No, first of all, in my case, I don't do dual agency, so I'm referring one of those parties out. So I will make less money than if I sold that buyer a different house and got my seller's house sold. So I don't have a profit motive. I make less money usually, so that doesn't exist, as sellers will perceive this double paycheck argument. But even if you were legitimately going to get all of both sides of the transaction, if you really have undertaken a house hunt with the buyer who ends up buying that house, should you really be getting paid less than your full transaction side, which is what you would have been paid if they bought anything else in the MLS? It doesn't make sense, because you really will have done 2 transactions worth of work. So the seller may think it's a double paycheck, but really all you're doing is combining 2 separate units you would have had to do the full load of work for into one transaction, but you've still done 2 transactions worth of work. So one of the things that we always have to be mindful of is the brokerage fee multiplied by that seller's selling price is a large number. Just in terms of total dollars, that's always going to be a big number. We always want to make sure sellers know that we're very sensitive to that and that we're not treating it cavalierly because it's not our money, it's theirs. So anything you can do that helps dissuade them from thinking that you're getting a big, easy double paycheck is very useful. So once you explain, no, it's not a double paycheck, it's 2 separate transactions worth of work, because I will have done a full house hunt and a full home purchase with those people, and I will have brought your house to market, paid for all the marketing like I normally do, and will have shepherded you all the way to closing. So there will be 2 full transactions worth of work if that were to work out. And statistically, dual agency is only something that comes up occasionally, not super often. Well?
The question I had is backing up a little bit. Did I hear you say that if you have a seller and he has a buyer, you're suggesting to him that just hold off from listing it with you for a week and 2 weeks?
If they're not open to a full exclusion, if they're not open to dispensing with the exclusion, with not having one, then so I would suggest to them, especially if you're at a time of the year like now, where people that are thinking, should I put it on now, should I not? Yeah, you should have had it on about a month ago. So if you're really time sensitive, you need to make sure that they know, don't wait around a long time and let this buyer decide. But I get, because it's part of explaining I'm not being greedy, Mr. and Mrs. Seller, I get that if there's an opportunity to make it sell without having to pay me for it, that totally makes sense. More power to you. You will honestly have all of my best wishes if you can make that happen. Understand, I can't start doing the work. I can't drag thousands of dollars of camera gear and start spending hours and hours of time on marketing your listing, which I do up front, most of which before it actually hits the MLS. I simply cannot do that and be poorer for having ever met you if that exclusion were to buy. So if you think that's a really serious prospect, and if you don't like the idea of having to pay a realtor if that prospect buys it the day after you list, let me suggest you give them a hard and fast deadline, so that way you're not on the hook. Before you're on the hook to pay me a dime, tell them they've got a deadline because you're going to get it listed.
The alternative, though, would you not write the listing with that exclusion in there for 1 week?
No.
And then that buyer would have no representation?
I normally wouldn't. That's totally your own judgment call. I wouldn't. I just don't like having the exclusion there, because then the other problem that occurs is then you have to indicate in the MLS listing that you have exclusions. So the other part of this that warrants explanation to the sellers, so they understand that you're not greedy, you're not looking for a quick double paycheck, but also they understand that almost every one of these dual and variable commission arrangements and exclusions, those have negative impacts on the marketing of the property. They create marketing impediments because they both trigger disclosure requirements. And at a minimum, it wastes our time when we're working with buyers if we see a listing that has exclusions, must call for details. So then you play some phone tag to make sure that you don't start showing a property for which you would get paid exactly nothing. So at a minimum, it's going to waste some of your time. At best, it's going to cause some people not to see it. So when you explain to a seller that a dual or variable, and then on the dual and variable commission front, here's the marketing impediment explanation there. Because remember, I said you trigger the disclosure requirement if it's codified in your listing. It does not in any way preclude your on the fly making a commission concession when a circumstance arises. So what I will tell a seller is, because on the one hand we have an obligation to put our agreements in writing, what I will tell a seller is, I am not going to have a dual or variable commission. I'm not going to offer you in the listing a discount if the buyer doesn't have an agent. And here's why. That's known as a dual or variable commission scenario. I will then have an obligation to disclose it in the MLS, and that's going to cause 2 problems. Number 1, it will make buyer agents less likely to want to show your property because they can see that that shown to the entire world is this indication that buyers may be able to save a few bucks if they ditch their buyer's agent. Is that a good way to curry favor with buyer's agents? To put out there for the whole world to see, better deal can be had if you ditch your agent? No, of course not. That is a marketing impediment. Sellers don't know that. I wouldn't expect sellers to know that. But when you explain it, again, not a sales pitch, just explain the impact that has, and they will start to put the pieces together and realize that is not good. And then you reiterate what I said with the exclusion conversation. And furthermore, we don't want the buyers without the buyer's agent. They're twice as difficult. So you may think that there's money savings potential, or you may think that if there's not money savings, I'm getting a double paycheck. No, I would way rather they have a buyer's agent, because the probabilities of it getting successfully to closing are much, much higher. So then I would tell the seller, I'm a business person and I'm a pragmatist. I am not so stupid as to let your house not sell because I'm holding out for a double paycheck if we legitimately were to have a buyer who dropped out of the sky, who didn't have their own agent, and I could confirm that they had not been working with one, so it wasn't that they were ditching the agent in the hopes of saving a few bucks. So please accept my assurance that if a circumstance were to arise where that was a pivotal part of it, I certainly would be open to making a reasonable commission concession if those circumstances arise. But the last part of it is I make sure I set the stage for reasonable expectations, because seller is thinking, all right, well, if there's no other agent involved, then the discount should be, they think it should be cut in half. Discount should be half. Okay, so you don't have the other agent, but cut in half. So the other thing you want to do is explain up front, a reasonable commission concession does not equal 50% discount. And the quick explanation to that is because even if that buyer has no agent, and even if I have not had to undertake a house hunt with that buyer, I will still be having to show up and do a bunch of the tasks that a buyer's agent would have been doing, which is part of what I would have been paying the buyer's agent for via the cooperating compensation. Therefore, by the time I'm the one providing the access and doing the showings, providing the access and sitting at the home inspection, scheduling their side of the closing and all of those tasks, even though in that case I'm exclusively representing the seller. Because if it's a buyer I really don't have an agency relationship with, it's a disclosure of no agency, and I still maintain my status as the exclusive representative of the seller. So I have to make sure that they know I'm still on your side only, but even so, I am having to show up and do a bunch of the tasks that would normally be on the buyer's agent's checklist. And as a result, a commission concession does not mean a 50% discount. It would commonly mean a 70% discount, so I'm getting paid, one side plus, a third, or something like that. But again, the point is, let them know I'm not going to codify that in the listing because it will create this other marketing impediment, the dual or variable commission disclosure, which then causes an impediment. Makes you more likely to get buyers who ditch their agents, which is bad for you, Mr. and Mrs. Seller. You think there's savings to be had, but there's not. And it creates a marketing impediment because anything that makes other agents, the other 436 of us in the market, less likely to want to show your property is a bad, bad thing for you. So here's why I don't codify it, but I'm a pragmatist, and if the circumstances arise, I'm very open to it. I will also throw out there that if you're lucky enough to have multiple offers, I will not do anything that disadvantages the buyer that has an agent. So I won't offer a discount that will open us up to some other agent who brought a buyer and an offer in good faith saying, you cut that buyer a deal so you could get both sides. And when you just explain that in the context of that's just fair play, so that I don't open myself up and you up to liability from an agent alleging that there was some sort of an unfair dealing. So again, it's all an explanation and a dialogue. There's really not much sales pitch to it, but once you kind of know what those talking points are and can start those conversations, it has been years, if ever, since I've had to do an exclusion on a listing, because they tend to get it. Other thoughts or questions on that subject?
Especially if you can quantify what listing costs are, at least in front end. People just think they're sticking a sign in the yard and putting the MLS, which is for free. They don't understand really any kind of specific numbers that go with that stuff. So whether it's a home site, whatever it is, you can add those up pretty fast, and you could have $700 or $800 right out the door.
Yeah. And you can mention up front, use your own judgment, but for those of us who have administrative assistants, there's a lot of personnel expense in every listing that's taken because I'm paying Tracy for the time that she's spending on it. Even if it were to sell to their exclusion, she's still going to have spent hours on it that I'll be paying her for. If you don't have an assistant, think of how to best package that argument. So whether it's this many hours of your own time, which is either time you could have been generating revenue with a different client or time you could have been with your family, or you can let them know in general numbers. Here's what it cost me a month just to be in business. You know, I have errors and omissions insurance. I have a lot of costs associated with being in business. So if I sign up for something with an exclusion and I turn your listing into a lottery ticket as opposed to you're paying me to render services and I can reasonably expect to get paid if I do my job, and instead you want to turn it into a lottery ticket, you know, I'm a business person. I'm going to have to focus my efforts elsewhere. Okay, so any other questions on dual or variable commission or listing exclusions? Because the other item I wanted to discuss was attorney stuff. Yeah.
Yesterday, I had a for sale by owner that I had shown earlier, and she called me and she says, I have another agent that showed my property that has made an offer. What can I pay you to finish my side of the transaction? She lives out of town. She says, it's awkward. What would you charge me if I just wrapped up my side? So I said, I'll charge you. Just wrap it up. I don't know if she's going to or not, but I hadn't had that before.
Of course, the big thing there is case-by-case basis. Make sure you talk to that person in enough detail that you have a reasonably good sense. Because you know the risk there is they could have dug themselves a terrible hole, and what they're doing is throwing you into the middle of it, and you might think whatever price I named isn't even beginning to touch what it would be worth for me to have gotten involved. So just be very careful. But I think Russ had one of those not too long ago as well, where somebody had asked him basically to come in and finish it.
Michael just did that. He had a client who he was their buyer's agent on a house they purchased, and their next door neighbor bought their house, and they didn't want to do anything with it. So I think he charged them. And he had a no agency thing signed with those folks. I mean, he did it all right, but it was kind of interesting for people to ask.
Because you think you're coming in midstream, and therefore there's really, you're not going to be paying for multiple months in the real estate book or any of that stuff. Yeah. But it doesn't mean that you can't still do 3/4 of the work after the contract.
Even though he didn't have any parties, he still had 2 parties to the transaction.
Yep. So be very careful before you agree to doing some sort of a cut rate deal. And I don't say that from a sales standpoint, wanting to gouge clients. Just it's easy, as Bill pointed out, it's easy to underestimate how much work can end up needing to be done post-contract.
So how do you document that? With a regular listing?
Yeah, I would do, because under the license law, you still need to have a paper trail that shows who you represent. So if it was a buy,
we did a listing with that person.
So you'd either on the seller side be a normal listing, and with a buyer it would be at a minimum written notice of designated agent, and you're going to want, if it's a buyer with an unrepresented seller, you're going to for sure want a compensation agreement. So the attorney issue that's come up, I've had 2 different agents in our firm in the last week that have had clients that got themselves into jams that were very, very avoidable had the clients been more willing to use attorneys. So are all of you familiar with the attorney checklist and the buyer attorney checklist and waiver form? How many of you have had occasion to use that at some point, or at least to brandish it? Bob, no? Okay, so the agents that I've talked to since that form was developed, what it was is, I wanted to provide a form that would be compelling and explanatory, so buyers would know. I don't want buyers to see this as, I have an opportunity to either spend money or to save money. Well, if they think of it in just those terms, they will go for that I'm going to save money every single time. They have to understand that there really is value in having an attorney involved. There's value to us in having an attorney involved because it's a huge risk mitigation tool. But there is value to them, and there's value to them partially analogous to an insurance policy where the payoff is huge if something goes wrong, if disaster strikes. But even more importantly, there is value to them even if everything goes right. The attorney still will have a job to do, and there are a lot of tasks getting done that simply would not, or that wouldn't get done as well if the attorney weren't there. So I put together, with the input of 2 different attorneys that we work with, that our agents work with on a regular basis, a list of all of the things that a buyer's attorney does, because buyers often don't know that. And I think one of the things, I think it was Edna and I that were talking about it, they have a transaction in a different state where they think, I don't have to have an attorney because all that stuff did get done. Either my lender did it or the title company did it. And of course that varies a lot, not just from state to state, but from here to Decatur it's drastically different. So they have to understand the fact that you didn't have an attorney in a transaction elsewhere doesn't mean that you shouldn't have one here and now. So that form has a long list of all the things that a buyer's attorney will do And if you have a stubborn buyer who says, I do not want an attorney, then it also has a waiver and asks them to sign, indicating that they've seen all of those benefits of having a buyer's attorney and that they are very specifically opting not to have one and to forego each and every one of those benefits. Because if you have a buyer who gets into trouble down the road and didn't have an attorney, you don't want the buyer saying, well, he didn't say I needed one. You want to be on record having shown it. But more importantly, showing them the form almost always gets them to get an attorney. That's the more important thing. I care more about getting them to have an attorney than I do about the waiver. But once you finish that off with a waiver, that makes them a lot more likely to think, the agent may know more about this than I do. There must be stuff I don't fully know, and therefore it's worth having. So going back to the stories that we had this week with our agents, both of them involved a lack of appropriate contingencies in a contract. Both required very minimal amounts of custom drafting to make the contracts perfectly tailored to what those particular buyers needed. And in both cases, the custom drafting work that should have been done, that would have taken just a few minutes by the attorney, didn't get done. Something took an unexpected turn later on in the transaction, and the buyers in both cases are worse off because of it. So in one case, we have an agent who had a buyer that was making an offer contingent upon a property that was already under contract, closing and selling. If you're making an offer that has a financing contingency, you don't usually have to have any sort of a separate contingency for the successful closing of that pending sale, because the successful closing of that pending sale is already subsumed in what existing part of our contract. Exactly. Yeah, exactly. So even if you had a buyer who could afford to buy it without the property having sold, in almost all cases, and think about this the next time it comes up so you're sure to analyze it, but in almost all cases, even if they could put the transaction together without their pending home closing successfully, usually the percentage down payment and the specific terms of the financing contingency were written to contemplate the amount of money they would have on hand if and only if that transaction successfully closes. So then it's not a matter of if it doesn't close, oh yeah, but you could still get the financing. Yes, I could, but I could not get the financing I described in paragraph 19, which contemplates 20 or 30% down, because the 20 or 30% down can only happen if I have that other property sold. So make sure you let the other agent know so you don't sneak that in, but the reality is you can use the financing contingency to bail out if something goes wrong with the pending sale that was a prerequisite of the purchase closing. But in this case, it was a cash purchase, but the cash purchase was contingent upon cashing out of the one that was under contract. So there you don't have that contingency subsumed within the confines of the financing contingency. So therefore you really need a custom contingency for that purpose. Our contingency for home sale, for sale of buyer's residence, really is intended for use in cases where the buyer's residence is on the market, not a case where it's already under contract awaiting closing. That really needed some custom drafting, and it didn't get it. And so then it wasn't totally clear if the transaction, the predecessor transaction, fell apart, the one that was already pending that needed to close. Is the contract off? Is it not? Do you have to serve a notice to terminate? Do you not? None of that was clear because somebody had just written sort of a quick, vague note about contingent upon this closing. Well, then the other dimension to all of this, because I was talking to that agent and said, does the buyer have an attorney? No. I suggested they get one, they wouldn't. Well, then you add another interesting dimension to all of this. That buyer was intending to do a 1031 exchange. Exactly. So it's like, without an attorney? Yeah. So I mean, there's a compelling case to be made for why every buyer in every run-of-the-mill routine residential real estate transaction or market needs to have an attorney. But there is no question you must have an attorney if you're trying to work this all into a 1031 tax-deferred exchange. But for a couple of reasons. It's complicated and the stakes are high. If you screw any part of that up, you completely will have invalidated the tax-deferred arrangement of the whole deal. So depending upon how much gain you were deferring, you could screw one step of that up and fail to follow the letter of the tax code and owe thousands or tens of thousands or hundreds of thousands of dollars. And all because you weren't willing to spend a few hundred to have an attorney involved. I mean, that's absolute insanity. So we as agents need to be thinking in terms of, Ask the questions because because we know more than they do in terms of we know why they should have an attorney involved. They don't know. It's our job to explain it to them. So when you learn tidbits like, and this agent didn't know they were going to do a 1031 exchange until after she was way deep into the transaction. But when you find tidbits like that out, then you can present the attorney part of it as not even an option. You have to have an attorney. And in this case, not only do you have higher stakes, but a 1031 tax-deferred exchange also requires that the seller jump through a few hoops. Documentation-wise, it's not going to cost the seller anything extra, but if you don't have the seller signing a contract where the seller explicitly agrees that they are going to cooperate with a 1031 exchange on the buyer's part, then you may have a seller who just says, I'm fulfilling all of my obligations, I am performing as required under that contract, and nowhere in there does it say I have to jump through this hoop, and this hoop because your attorney keeps sending me garbage about some 1031 that I don't care anything about. If they know it up front and it's in the contract, they will always agree to it because it doesn't really impose any major burden. It's just that they have to cooperate, but it doesn't cost them anything. But the language has to be in the contract or you have no guarantee the seller will cooperate with that. And then your whole 1031 is out the window. And then you're back to thousands, tens of thousands, hundreds of thousands of dollars of taxable gain that you thought you were going to defer when you started the whole process. So not having an attorney in a 1031 is about as insane as anything I've ever heard. But think of that when you're dealing with your clients and other situations, anything that goes off the beaten path. Or put differently, any scenario that makes you think that my pen, as the buyer's agent, that my pen needs to be jotting anything into the margin of the contract other than a lender-permitted closing costs and other prepaid items type of credit. Really anything beyond that, if you think this really requires some explanation or some additional verbiage in the margin of the contract, then you need an attorney. And make clear you can't go down that path. Turn that into don't turn it into a negative for you, turn it into a positive as to why they must have an attorney. You, Mr. and Mrs. Buyer, may think that that's an easy matter, but if we start to put in how we think we want the radon issue resolved if it tests high for radon, we need a lot of very specific things. We need to know that it's going to be mitigated by a licensed contractor. Is the contractor going to offer a warranty? I've talked about all these things before. It's not just a matter of if it tests high, seller pays half. That does not cut it. There's a reason why attorneys need to be involved. It's their job to think ahead 3 or 4 steps, think of every possible direction that it could go, and make sure they have planned for it. Number 1, they're less likely to fail to plan for all of those possibilities. And number 2, if they fail to do that, whose problem is that? It's the attorney's problem, not ours. We'll feel very bad for the client if the attorney screws something up, but it will be the attorney's problem and the attorney's malpractice insurance, not our problem, not our E&O insurance. So, as I said, put differently, any situation that makes you think something has to go in the margin here, that is a big alarm bell for I have to have an attorney involved, and I need to find a way to make sure that I explain it, not a sales pitch, not a way that makes me sound like my hands are tied, I can't do my job for you, but I need to turn that into a positive commercial for here's one of a million different things. An attorney would be doing a bunch of things for you even if you had nothing out of the ordinary in this transaction. But because of fill in the blank, we need this custom drafted. And it'll probably only take 5 minutes, but an attorney has to do it. Walt?
If you represent an out-of-state investor that's doing a 1031 and has an attorney representing him in the state that he lives, wanting to buy something here in this state, and you're representing him as a buyer, would you recommend that he gets a
local?
Illinois?
Yeah. So, but you raise a good issue because in terms of familiarity with the tax codes, of course, that's nationwide. And so that's not specific to state-by-state licensing or state statute. So an attorney from California's ability to navigate the murky waters of a 1031 or a reverse 1031 is not going to be dependent upon what state they're licensed in. So they may be perfectly competent for that. But if you're using a qualified intermediary that is, for example, Chicago Title in Champaign, Illinois, do you want a California attorney to be the one that's helping to interface with the qualified intermediary in Illinois when they've never done that before? No. So again, I'd just turn that into, be really careful, because if it's somebody they already have a relationship with, you don't want to throw their attorney, who may be a great, great attorney and who may be an expert with 1031 exchanges, you do not want to throw them under the bus. But throw up some cautionary flags of, if you're going to be dealing with Chicago Title or a local trust company who's going to be your qualified intermediary for your 1031 exchange, you're probably going to want to use somebody local, number one, because all the normal parts of the real estate transaction are specific to Illinois and to our local market. They're going to be totally different than California. But number two, even the 1031 parts of it, where your attorney in California may know the tax code like nobody's business, they still don't have the experience dealing with our local qualified intermediaries that are a critical part of pulling off a 1031 successfully. And honestly, I'm guessing Jamie's thinking, he might as well be speaking Greek. And even for those of you where you get to some of these explanations and that's what you're thinking in your head, if you can say half of that and just have it roll off your tongue, the more important point is the buyer needs to realize, holy cow, this is way more complicated than I realized. So honestly, even if you don't understand any of it, and most of you in the room understand the basic framework of it, but even if you don't, you just have to get out there. This is complicated and can turn into a complicated, high liability, high cost mess. And the easiest thing you can do to make sure that doesn't happen is spend a few $100s on an attorney.
You mentioned you have a form, or is that form in-house?
It is in-house, but it's available to all of our agents. I've emailed it out before, and I'll be glad to do it again. It's beautifully formatted and branded. And if you look at it, it's got, you can see all the bullet points. That's the list of things that the buyer's attorney does. And those were carefully worded with the input of 2 different local real estate attorneys.
But we don't have it in there in print, on the shelf in there.
I can make hard copies if you want. I think it's been emailed out once or maybe twice. I'll be glad to get hard copies out.
Okay.
Good question.
So you'll print one already.
AOL.com.
A little coloring.
Well, speaking of 1031 exchange, I've encountered once or twice where buyers have heard about 1031 exchange, and that's what they want to do for their personal residence. You know, it's like, oh yeah, I get, you know.
Uh-huh. No, you have something even better for your personal residence. It's called all-out exclusion.
It's called, you know, they're trying to be creative.
Yeah, Pete?
Did you have any discussion before I got here about the whole radon issue and writing things in the contract?
Well, we discussed that before, but...
No, but I mean...
Yeah, no, not today. Does anybody have... Yeah?
I have an interesting...
Class, Pete's talking. Pete's holding the magic rock.
Is that what's in your book? No, I had a very positive byproduct from my, forcing myself not to pick up the pen and write margins, because I found out that when you make it part of the post-inspection timing, and you get the thing done, it doesn't end up on the contract, obviously, and then the lender's not aware of it, and the lender doesn't force you to get the mitigation done if the test fails. Retest it again and drag that whole thing out and possibly, mess up the closing time. I've got a situation now where we're closing next week and my buyer is getting the credit.
Okay.
He can put in the mitigation system when he feels like it.
Is he doing the credit as a closing cost credit? Good. Okay, so Pete's point was a really, really good one.
So it's really slick, because I
Yeah.
checked it through a local...
I had one of those recently as well.
Yeah, and I called one of my favorite lenders, and I said, okay, here's a hypothetical.
Right.
Because she's handling the loan.
Right, and just said closing cost credit.
If it's not on the contract, no, they don't know anything about it.
So we have talked many times about mortgage fraud. Bottom line with mortgage fraud is, do it, don't do it, don't do it. So that's very, very important. But Pete's point is, if you put, or if anybody puts radon-specific language, like if the buyer's going to test for radon and if it tests high, here's how it's going to be dealt with. What does that do for an underwriter at a bank? They're seeing radon, and so suddenly they're going to demand follow-up documents. I want to see the test. If it tested high, I don't care if the parties have already come to an agreement for how it's going to be mitigated or who's going to pay for it. I need to see that it was done before closing.
And a successful test.
Right, and retested. So Pete's point is, in this case, if you're handling it just like you would any other post-inspection unacceptable deficiency, then the contract itself, which is what the underwriter at the lender is referencing, won't have any indication of that. And so you're going to legitimately deal with it as a post-inspection agreement. That post-inspection agreement, since we can't just do repair credits, if it lists a credit, the credit will be, the vehicle for delivery of the credit to the buyer will be by adding a closing cost credit to the face of the contract. The reason that's not problematic, as long as you're within the limits of what closing cost credit amount can be used, the reason that's not really problematic is lenders will allow closing costs for any reason or for no reason. They don't care. So in that case, radon comes up as an unacceptable deficiency. Notice is served, but there's not a word on the contract about radon. It was just something you did just like you would any other part of the inspection process. So then you don't have an underwriter who's demanding to see a bunch of follow-up documents. Now, in many cases, we've gotten people like Paul Muser to do radon mitigation systems very, very fast and bill it at closing, and it's either paid for entirely by the seller or it's split, but whatever. The bill is there at closing, the system is done. So far, I've not gotten into mandatory retesting, but that does add a huge additional time crunch with the lenders that say, no, we don't just need to see that it's been installed by a reputable licensed mitigation contractor who warrants that it will reduce the radon levels to lower than 4 picocuries per liter. In addition to making you get all the installation of the system done before closing, we are further going to require that you do retesting, which of course is a delay of several days. The days needed to get the testing equipment available and placed, and then the delay before it's picked up. So that's actually a really good point. Whenever possible, we want the radon stuff just done and fully mitigated, because the other practical reason is, how many of us have had buyers that bought something, got a credit to repair it, and then we go to list the house 5 years later, and they remind us they got the credit and never did the repair. So, and then at that point are in an iron lung. So we don't want that to be the case. So that's a really good point. So with the radon, don't ever write anything about radon in the margin. Within a few weeks, hopefully, the new contract will be more explicit about radon is one of the things that you absolutely can be testing for.
I have a follow-up to that. If it's not on the contract, it should not come up at closing. The R word should not be mentioned anywhere,
Right.
except if you say repairs, but the other R
Right.
word is something that doesn't come up at closing.
Right. Any other questions? All right. Well, I got to get to a closing. Thanks for being here, guys.
Thank you, Matt.